Welcome to an oral argument session of the 5th District Court of Appeal. We are streaming live on YouTube, just so everyone knows. It is 10 o'clock, and we have case 20-1498, Arnold Jr. et al. Versus Arnold Groves and Ranch et al. I'm Judge Eisnagel. We have on the panel today Judge Sasso and Judge Nardella. And with that, counsel for the appellant, if you want to let me know how much time you'd like in rebuttal, I'll attempt to help you remember that.
Yes, thank you, Your Honor. I'd like to reserve 7 minutes for rebuttal, please.
All right, 7 minutes. You should watch the clock as well, but I'll try to remind you when we get there. And with that, counsel, whenever you're ready for the appellant, you can proceed.
Thank you. Good morning. May it please the court. I am Patrick McGee, representing appellants, defendants below, John Arnold Jr., J. Robert Arnold, and JJJR Properties, LLC. And this is an appeal of a post-judgment order. It was an order that was entered after my clients appealed the trial court's final summary judgment. And as between appellants and appellees, the final summary judgment was a mere declaration of rights, nothing more. This appeal concerns fundamental issues of the trial court's jurisdiction to adjudicate and impose new, unpleaded, and extensive coercive and executory relief, but all done while the Declaration of Rights is under review by this court. The order under review refers to enforcement of the final summary judgment, but the bare declaration that was the final summary judgment had nothing in it to enforce. It was not a money judgment. It did not decide a claim for possession of property. Instead, the order under review, the order granting motion to enforce, made new post-judgment adjudications for which the trial court lacked jurisdiction. And there were—
Mr. McGee, can I ask you a quick question about the bare declaration that we're talking about?
Yes,
when we talk about the declaration that the trial court made, are we looking at the final judgment for that declaration? Are we looking at the order granting summary judgment? What do you contend is the declaration that the court made below?
Your Honor, as far as the judgment goes, the declaration is rather sparse, and it's in the final judgment. Now, you'd have to go back to the various orders, probably the last one being Judge Munyon's order from October of 2019, in order to put some meat on the bones in that regard. But even at that, Judge Munyon's order, which was a rehearing and basically a reconsideration of an earlier order, did not adjudicate a claim to possession of property and did not vest title in the plaintiffs.
I understand. So your argument today is not simply that it's the final judgment granting counts 7 and 8 as the bare declaration, that you can look back at the previous orders to put that in perspective.
I don't know that there's a precedent for looking back at that, and the final judgment should have been a declaration. So you're looking at a non-final order that granted summary judgment. If there was a declaration to be made, it should have been incorporated into the final judgment in our view. But even at that, in order to understand what was going on, you have to go back and see what was pleaded in the first amended complaint, which was for a mere declaration. There was not a claim for supplemental or coercive relief in that.
Doesn't the motion to enforce, though, request in the alternative? I think it states, to the extent that such relief has not been previously requested and granted, the court has authority under 86.016 to grant the relief requested in this motion. So why could not that motion to enforce be treated as a motion for supplemental relief under 86.061, and does that matter?
Well, it should not be treated as that type of a request. In fact, counsel, Mr. Simmons, represented to the court at the May 12th hearing on the motion to enforce that we need not follow those procedures under 86.061 because the show cause process under 86.061 need not be followed because of an update in our rules of procedure. So in the first place, it was not followed. It was just done. And in the second place, the court didn't have jurisdiction to grant that type of supplemental relief. Your
argument turn on that the court, even if it was appropriately treated as a motion for supplemental relief, that the court would not have had jurisdiction to grant supplemental relief under the statute.
Well, that's certainly another layer to our argument that the process under 86.061 was not waived by my clients, but the court didn't have jurisdiction to grant that relief. You can look at the Palma Sola case, a second DCA opinion, which was related to a declaratory judgment saying that the trial court lacked jurisdiction except with regard to those matters that do not interfere with the power and authority of the appellate court or with the rights of the parties to appeal, which are under consideration by the appellate court. Certainly, the post-judgment orders interfered with that.
Well, counsel, I mean, I think that's the key issue. I mean, you just kind of glossed over what I view as the dispositive issue is, does this interfere with this court's ability to review the final judgment or not, right? I mean, if it does, then the trial court lacked jurisdiction. If it does not interfere, then the trial court was free to do so under 86.061, right?
Well, aside from our argument that 86.061 procedures were not followed, I think that is a very important point that you've mentioned. And in fact, what the declaration purports to relate to is the conveyances that vested title to the various properties in my clients. Now, if that mere declaration is under review and this court decides that the summary disposition was erroneous, and we think we have a very strong brief before the court that it was, then how is it that this court could grant effective relief by reversing that declaration if the property has already been conveyed in some fashion to the plaintiff?
Counsel, I definitely picked up that argument in your brief. It's an interesting point, but the thing that I struggle with on that particular argument is why couldn't the same thing happen again that's happening right now? The trial court orders, the fact that all these properties and assets were conveyed away from Groves and Ranch, it's not that there's not a remedy for that, right? The trial court's already fashioned a remedy, convey it back. I mean, why does that just because assets move back and forth, why does that make the final judgment unreviewable by this court?
Well, the final judgment is certainly reviewable, but it's the relief that you cannot grant.
Why can't we? I mean, the trial court has granted relief to Groves and Ranch by saying, "Hey, give the assets back." If this court determines, "Hey, the summary judgment was in error," and reverses it, why can't the same thing be done again?
Well, this court's permission is required in order to grant that type of relief, the type of post-judgment relief that the court granted. Now, if the court wants to address the possession of the property after judgment, there are other factors, other procedures available, such as a receivership that doesn't shift $2 million, for example, to the plaintiffs that under an unpleaded claim that you can just be spent and not returned. So in that regard, I think the instructive case is Hudson versus Hoffman, where you had a mere declaration regarding a mobile home park and the costs of water and sewage improvement, whether that cost could be passed along to the tenants of the park.
How is that case applicable when it relies on two other cases that are no longer good law?
Well, I mean, it's the understanding of the case, of the process as to what supplemental relief is, and it's a jurisdictional issue.
Go ahead, Judge.
I think what Judge Sasso is asking is I think a very important point here on this appeal. The holding in Hudson says that the trial court has no jurisdiction to do anything with matters, quote, related to the final judgment. And that's the rule that Hudson states. And I agree with you, Hudson is the most on point case, but it seems to misstate the actual rule for jurisdiction. And that was recognized by the second district in Bernstein versus Barron a few years later, where they said, no, we got it wrong. in Wilson Realty, which is the case that Hudson cites, that it's not, and here's the quote, the test to determine loss of jurisdiction is not whether the trial court is proceeding in matters related to the final judgment. Rather, the proper test is whether the trial court is proceeding in a matter that affects the subject matter of the appeal, right? So the second DCA has recognized essentially that the rule stated in Hudson and relied on in Hudson was incorrect. So doesn't that undermine the best case to support your position?
I think if you look at the opinions of this court after that, the 2018 opinion of Citizens Property, for example, from this court, where this court said that the trial court may not alter the substance of a final judgment or interfere with the appellate court's authority or the rights of a party that are under consideration by an appellate court. So we are interfering with the rights of the party that are under appellate court. I think it's more semantics in when you apply the Citizens Property verbiage to the principles in Hudson, that the court cannot interfere with the rights of the party under consideration by the appellate court. Certainly,
the rights of the party as established by the final judgment, correct?
Well, the declaration is between the parties. Yes, Your Honor. So you have these underlying principles. I don't think they're as narrow as looking at the exact language that was used in the Hudson case and saying, well, that case has no application whatsoever when we're dealing with the circumstances that we have here, because I've also cited to you the list of cases that deal with the limited jurisdiction and that the lower court is divested of jurisdiction to proceed with matters related to the final judgment. There's the Jalali case, the Citizens case, etc. But you also have cases that talk about the jurisdiction of the trial court and the necessity to have supplemental relief in connection with an appeal. And one of those would be the Coscott case. And that's a second, a fifth DCA case, actually from 1970, talked about the fact that supplemental and coercive relief is that which may be necessary to make the declaratory judgment effective. However, the lawful process contemplates additional adjudications. So those additional adjudications here that affect the property rights of my clients that are under appeal, and even property rights that are unpleaded here, the right to possession of property, the necessity to empty bank accounts, the money held.
Counsel didn't, I mean, I think that your opposing counsel will say, look, the declaration established all the property rights, right? I mean, you said that this order on appeal affects, changes the property rights, but I think counsel would say, no, look, the declaration itself established the property rights.
If I could put a finer point on that, the post-judgment order affected the possessory rights to expansive properties. I do not believe, and it's not our position, that under Florida law, the declaration was sufficient to vest title in the plaintiffs to this property. You can look at the case law and the judgment itself, and the judgment did not have a legal description of any property. Right. It did not otherwise describe the property.
Counsel, I think that's correct. I mean, I don't think the final judgment could be used, it couldn't be recorded to transfer the property. I don't know that any serious argument could be made. I think the bigger question is how do we apply the facts of this case, right? The case that is most on point for you is Hudson. I mean, as I think you recognize in your initial brief, that's the case you cite, and it's on point. I think the problem is that, Bernstein calls it into question later, just 2 years later.
I agree that it called it into question, but the point that I would make is that the issue on which that case was called into question is adequately addressed by this court in later cases, such as the Citizens case, the Jalali case, and so forth. Those principles still apply. If you look at the facts of our case, those principles should apply to our case, especially when you have a declaration that is so sparse as this that did not vest title in the plaintiffs. And
Is
so
it your position that supplemental relief under Chapter 86 can never be granted during an appeal of a final declaration?
No. Certainly, if it was requested, this court could use its discretion to relinquish jurisdiction to the trial court.
So you think jurisdiction would always have to be relinquished? In other words, a trial court never has jurisdiction to grant supplemental executory relief under 86 absent a relinquishment of jurisdiction from the appellate court?
Judge Sasso, I don't know if I could go that far as to make a blanket, because there are so many different factual situations that can come up. I can certainly say under the facts of this case that the type of relief that was granted, even if you try and place it under the umbrella of supplemental relief, so affects the property rights and is done without procedural jurisdiction as well. Let's not forget that there was no cause of action for possession of bank accounts. There was no cause of action to compel third parties under threat of contempt.
Well, counsel, the statute. Go ahead.
Just and if you want to address this on rebuttal, you mentioned that you argue that supplemental relief was not followed, that the supplemental relief procedures were not followed. I'm not seeing that precise argument in your initial brief. So if you want to address that in your rebuttal argument where that was argued.
I can actually point you out, Your Honor, and I know in our reply brief we're dealing with that fact on page 11 of our reply brief, and I'll pull out our initial brief where we raised that as well.
All right, counsel, we'll save the rest of your time for rebuttal. And so with that, we will hear from counsel for the appellee. Counsel, whenever you're ready, you can proceed.
Yes, Your Honors, and may it please the court, I'm David Simmons with DSK Law, DeBovian, Simmons, Knight, Manzares, and Neal, and I'll be arguing on behalf of Alex Douglas, who is also represents Dr. Arnold and John R. Arnold Incorporated, and Scott Ross, who represents Arnold Groves and Ranch, as well as the individual siblings who were are limited partners of Arnold Groves and Ranch. Your Honors, the issues in this case can be summarized in the case of Parsons versus Whitaker Plumbing, because it provides that the general rule is that the lower court is divested of jurisdiction to enter an order affecting the subject matter of an appeal. And then the court said after that, if there's any issue about amending the for final judgment or things like that, then the court can go ahead or the party can go ahead and seek relinquishment of jurisdiction to make any kind of amendment to a judgment. This was not necessary because there was not an amendment to a final judgment. This final judgment held the transfers to be null and void ab initio from the very beginning. There were no conveyances that were required. All it did is say that the transfers that were made were void because of the reasons that are set forth and were thoroughly.
Counsel, if we conclude that Hudson is still good law, now obviously that's not binding on us, it's out of the second, but wouldn't you agree that to the extent Hudson is still good law, that case is pretty much on point, and it might require a reversal? I see you shaking your head. Why not?
Because the Parsons case goes on and explains what is the settled law in the state of Florida. And it says the above does not alter the well-settled principle that absence of stay or bond, the filing of a notice of appeal does not divest the trial court of jurisdiction to enforce a final order. That is the settled law in the state of Florida. And what happened in this case is that we did file a motion pursuant to section 86.061. And it does provide, and it's incorrect for opposing counsel to suggest that I didn't follow or we didn't follow the appropriate procedure with respect to.
Well, counsel, what I don't. Was there an order to show cause?
That's the point. Is that the considered view is that an order to show cause is not necessary. 86.061 doesn't require an order to show cause. 86.061 specifically says further relief based on a declaratory judgment may be granted when necessary or proper. The application, therefore, shall be by motion to the court having jurisdiction to grant relief. That's exactly what we did. We
But
filed-
counsel, then you're leaving out the second part of the statute. The court shall require an adverse party whose rights have been adjudicated by the declaratory judgment to show cause on reasonable notice why further relief should not be granted.
Yes, and the show cause is in the hearing and providing the evidence that would be necessary with the burden upon the defendant to go ahead and show cause at that hearing. It's a burden issue. The rules of civil procedure do not provide in the state of Florida for a show cause order, and nor does the legislature have the authority to go ahead and tell the courts how to do this process. And as a matter of fact, commentators, and that's what I was relying upon when I made the reference to Judge Jordan, that there is no show cause type of hearing or show cause type of order that is issued. It's encompassed within the motion and that is done, and then the hearing that is on it.
Counsel, I think your argument's a fair point, actually. But I'm not sure that this, where we've gone here, really has much to do with jurisdiction, right? I mean, let's say for a moment that the law did require a show cause order. That might be a procedural argument. That might even be a due process argument, which hasn't been made in the brief. But I'm not sure that that's a jurisdictional argument. So let's talk about under the supplemental relief statute 86.061. Counsel strenuously argues that, look, when you start actually ordering the conveyance of assets, the possession of property, it's his position that, look, that's a different order, right? That's a different relief. It's a different order than the much more general and broad declaratory statement in this case. Why doesn't that interfere with our jurisdiction to review the summary judgment?
Your Honor, the reason why is because there was no interference by simply enforcing the provisions of the declaratory judgment that was entered, voiding ab initio the transfers. As a matter of fact, after the court entered the order enforcing the declaratory judgment, as it was entitled to do to enforce it, what happened is that the defendants filed a motion for stay pending appeal on June the 16th, 2020, and the trial court heard that and then entered an order that said, subject to paying a bond, in effect, it said, if you pay this certain bond, then, and the defendant said they were not going to pay any bond. Of course, the stay was denied. Then the defendants sought review in the 5th District Court of Appeal, asking the 5th DCA to review that to determine the efficacy of it, the propriety of it, made the very same arguments that he's making here today to you. And the 5th District Court of Appeal denied the review. Why? Because it had determined that based upon these kind of circumstances in post-judgment type of scenarios, there are really two ways, just as the Parson case from the 4th DCA discusses, there are two ways to get to this issue of jurisdiction. One of them is do you go ahead, if we're not interfering, we are not outside the scope of the adjudication by the trial court that there was a voidness of the transaction. Then what happens is all the plaintiffs were doing were following through on the details of having that accomplished in accordance with Chapter 86. What happens is you can go ahead and ask for relinquishment. It wasn't necessary because we didn't impact. Under no circumstances has there been any impact upon your ability as a court to go ahead and do anything with respect to the underlying issues on this appeal. So there is no impact.
What happens? Let's say, for argument's sake, let's say that this panel affirms this order. And then of course the conveyances occur, and 6 months from now, another panel reverses the summary judgment? What happens?
We've not affected, and by the way, this court determined that when the issues that are the same issues that are argued to you about jurisdiction were made as a reason to set aside or to grant some kind of stay or send it back down, the 5th DCA refused to do that. And they determined that, of course, that the standard had not been met, which is probability of success on the merits, that the defendants could not show probability of success on the merits in their seeking of a review of the determination that it was not necessary to try to do anything to affect the enforcement of the court's order.
But certainly, are you suggesting that this panel is bound by the prior denial of review?
I'm only stating to you that the same arguments have been made and that this court determined that they were not ones that would have a probability of success on the merits. The point that I'm making or trying to make is that with respect to how this is accomplished, there has been no affecting the subject matter jurisdiction or the matters that are within the purview of your appeal on the merits. There has not, because all it did is if there had been a judgment that was entered in which there was executory process or anything like that done, those, as a matter of course, are continued to be processed. The mere fact that a summary judgment that is entered on a declaratory judgment, because see, a declaratory judgment, as you know, is just like any other judgment. The only thing that it doesn't have is the executory process that follows it, the enforcement, but you can go ahead and get that pursuant to 86.061. And so what has happened is that these judgments, this judgment was in fact one that we have not impacted the ability of this court to address in the future. As a matter of fact, that argument has been made in an effort to stay the underlying judgment, and that did not prevail.
So counsel, but let me go back to my prior question. And I probably didn't state it artfully enough. If we affirm today that this order, and then in the future, a panel of this court reverses the final summary judgment, right? Reverses the declarations themselves. What happens then? Just walk me through at that point, what happens?
Any conveyances that were made would be retransferred. Any issues as to the voidness of the real property transfers would be removed. And so nothing is going to be the kind of thing that affects the jurisdiction of the court to go ahead and deal with these issues.
Counsel says, but look, I mean, 6-8 months from now, that cash assets at least could be gone, right?
And Your Honor, that's the reason the Parsons and the settled law of the state of Florida is. The above does not alter the well-settled principle that absence a stay or a bond, the filing of a notice of appeal does not divest the trial court of jurisdiction to enforce a final order. Everything that has been said by opposing counsel about affecting or not having any kind of jurisdiction is subject to this well-settled rule. He had an opportunity to get a stay pending appeal if he thought that he could show a probability of success on the merits. Not only did the trial court reject that, but the 5th DCA rejected that, saying that he had not, or at least when they denied the review, ultimately concluding necessarily that he could not show a probability of success on the merits. And so the rules that he keeps citing are subject to the rule that you have an opportunity if someone is trying to enforce a judgment who has obtained a judgment, if they are enforcing it, seeking to enforce it, then there is a process. It is called seeking stay pending appeal and see what the result is, and then have, if you are not satisfied with that, as the defendants were not satisfied, they went and sought review by the Fifth DCA, and the Fifth DCA denied their review. So they've had ample opportunity if they wanted to effectively do that. They did, and they got their due process. You can
Thank you,
imagine,
counsel.
you can imagine the impact that this has had on Arnold Groves and Ranch and Dr. Arnold because of their taking possession of things that they should not have taken possession of. And so that is something that the court, of course, considered.
Okay, thank you, counsel. Any other questions from the panel? All right, counsel, if you have 6.5 more minutes, it's entirely up to you whether you would like to address any other issues, but it looks like we have no further questions from the panel.
I have a question for Mr. McGee.
Okay.
Mr.
ahead.
McGee, is there any argument being made in your initial brief that the declaratory decree, which references the plan of
Judge
dissolution,
Nardella, just
Yeah.
who are you directing the question to?
Mr. McGee?
Okay, we haven't yet switched over back to the appellant. So if you could just hold on 1 second, Judge Nardella. Counsel for the appellee, are you finished with your argument?
Yes, Your Honor.
Thank you, counsel. All right, counsel for the appellant, you have 4 minutes and 14 seconds, and I believe Judge Nardella has a question for you.
Mr. McGee, is there any argument being made that the declaration which references the plan of dissolution, that there are any assets which are ordered to be transferred in the order of enforcement, which are not linearly connected to the plan of dissolution, the valuation of assets, and the balance sheet in it? Is that an argument you're making in your initial brief?
Yeah, I believe that's within the scope of our custodial legis arguments, where the court is making these new claims that are not tethered to any pleaded cause of action. There was no cause of action in these two declaratory counts for which relief was granted for possession of property, for money damages, for anything of that nature. And with respect to what happens taking possession and enforcement, my clients did not take possession of property wrongfully. They had their possessory rights of all of this property prior to the time that the lawsuits were filed, and that was peaceably and consensually that they had possession of the property. And the whole idea that this is enforcement of a declaratory decree, you can see in the order itself, and this, for example, page 8 of the order, record 7578. This is the order the judge signed and the counsel prepared. It says that this court has jurisdiction to enforce its declaratory rulings that Arnold Groves and Ranch had full present ownership and possessory rights. There was no declaration that there were possessory rights, and there was no claim for possessory rights. There was no claim for ejectment, for unlawful detainer, or any other possessory action, nor was the judgment a judgment that adjudicated possessory rights. And we've cited some cases that deal with that. The Cohen case, for example, in Rule 1.580, that the gist of the rule is the court cannot order a writ of possession until there's been a formal adjudication of the right to possession of property.
Doesn't that argument turn on your broader argument that this was not supplemental relief and an additional pleading? It was improper enforcement of a declaration.
That is certainly fundamental to this, and there was no declaration, as some of these portions of the order say.
Does that argument hold, though, if this court determines that the motion was appropriately a supplemental relief motion and determines that the court had jurisdiction to grant supplemental relief pursuant to Chapter 86?
Well, I mean, that certainly undercuts quite a bit of what we're talking about. If this court were to determine that the show cause proceedings and those processes need not be followed or have been modified, as Mr. Simmons suggests, but you still have the right to possession of all of these cash assets. There was never a claim made for cash assets in this case. And neither was there relief granted in the declaration regarding cash assets. The order here, and Mr. Simmons refers to this as being null and void ab initio. There was never an order that ruled that it was void ab initio. Even a voidable conveyance conveys good title, which is what we have here. Even a conveyance obtained by fraud is merely voidable and not void.
That goes more to the merits, though, doesn't it? The merits of the whether the final judgment should be reversed. Could you, with your last remaining seconds, address that question that we had during your initial argument as to where in your initial brief the argument that supplemental procedures were not followed, supplemental relief procedures?
Yes, Your Honor. The bottom of page 21 of our initial brief, where we were citing Coscott, this court's opinion, and it says it contemplates additional adjudication with reasonable notice to the adversary and a right to show cause why relief should not be granted. And our brief says that never occurred here. I have a footnote citing what Mr. Simmons said at the hearings, and nor should it potentially have occurred unless and until there was a relinquishment of jurisdiction of this court under Hudson versus Hoffman. And
Counsel, just so we're clear, what didn't occur? There was no order to show cause, but there was an evidentiary hearing, correct?
well, yes, Your Honor. There was an evidentiary hearing on enforcement of the declaration that had already been made. So if there was to be relief under 86.061, there should have been a show cause order issued saying, here's what I want you, the defendants, to show cause why I shouldn't grant this relief. That would have given us the opportunity to do something in that case. We had due process rights under 86.061 that were not met here. And under the Lassiter case that we cite, when supplemental relief was not requested in the trial court, it was waived. So there had to be these steps taken for a supplemental relief. And don't forget
Counsel, your time, I think you've answered my question and your time has expired. Thank you to both counsel. It was well argued on both sides. And with that, we are in recess. Thank you.
Thank
Thank
you.
you, Your Honor.